There was a time when, as in the USA, there were 12 jurors who voted on a conviction in Germany. Watch this video to find out when that was and how it is today.
Welcome to YD. Why do Germans do things the way they do?
After we saw last week how convicted criminals are dealt with in prison, today we take a look at Schöffen, lay assessors, as part of voluntary work in Germany. In ancient Germanic times, it was a task of all adult men to judge crimes. To do this, they came together at a thing and then voted on justice and judgment. In the early Middle Ages, it became increasingly difficult to call all adult men together for this purpose. As a result, the term Schöffino, or ordering judge, was coined in the 8th century for the selected men who were now responsible for the task. Charlemagne institutionalized this and decreed that 7 men should administer justice. From then on, the nobles presided over the trial, but the lay assessors, Schöffen, dispensed justice. This type of court spread across large parts of Europe and even as far as England. The number varied locally from 7, 12, 14 to 24. The Schöffenbaren, aldermen, were usually free farmers with their own land, who were then appointed as Schöffen. This privilege was often hereditary and sometimes granted by the king, so that in some trials these aldermen even judged noblemen. With this task often came privileges, which meant that these aldermen grew into a kind of an elite. From the 15th century, traditional law was replaced by Roman law, and the previous lay assessors' courts were gradually replaced. This initially began with the highest court, so that the lower courts continued to be staffed by lay judges. With the conquest of Europe by Napoleon, the Holy Roman Empire also came to an end and French law was introduced in large parts of the German lands. These courts under French law were known as assises and were made up of geschworene jurors. As a result of the March Revolution in 1848, these courts also spread to other German territories. In the course of the Enlightenment, the idea was that the administration of justice should return more to the bourgeoisie from purely professional judges. On the 1st of October 1879, the Judicature Act came into force in the German Reich. It decreed that jury courts should be set up at the regional courts. 3 professional judges and 12 jurors were defined for this purpose. Even at the time, there was desire in various areas to set up lay assessor courts instead of jury courts. To this end, 3 times as many jurors were selected from a Urlist, original list, of German citizens who were eligible for lay assessor service, means who would have been available as lay assessors, as would have been needed for that year. The jurors were then drawn by a lot from those selected. As can be seen in American films, 12 were then selected from the 30 drawn by a lot to form the jury. In addition to tradition, the selection process was also criticized. For example, rejection did not have to be justified and was rather arbitrary and driven by prejudice. It also seemed that jurors were less likely to find guilt than could be assumed based on the law and the evidence. In 1924, under Erich Emminger, the separation of judge and jury was abolished in such a way that 3 professional judges and 6 jurors now sat together on the bench. Subsequently, in 1974, the current system was changed to 3 professional judges and 2 lay assessors, partly because it was more economical. In 2014, there were 37,000 principal lay assessors and 24,000 assistant lay assessors. At the Amtsgericht District Court, there is 1 full-time judge and 2 lay assessors, totaling 10,000 full-time lay assessors. If there is a small criminal division at the Landgericht, regional court, there is also 1 full-time judge and 2 lay assessors. The regional court has 3 full-time judges and 2 lay judges, totaling 15,000 principal lay assessors. There are also around 10,000 lay assessors at the youth courts. The term of office of the lay assessors is 5 years. In contrast to the election of jurors, people apply to become lay assessor and are nominated by associations. German citizens between the age of 25 and 69 who are in good health and have a good command of German can apply. Judicial officers, members of the government, and clergy are excluded, as are people who are insolvent, have a criminal record, or are currently under investigation. Lay assessors are deliberately not supposed to be people with legal training, but should judge with common sense and in a realistic manner. The people who have applied or been nominated are then available for election, which in the end can hardly be rejected. The lay assessors take an oath of office like a professional judge and also have the same rights and duties by and large. The lay assessors sit next to the judges at the bench. However, the professional judge conducts the questioning of witnesses. The lay assessor either submits their question to the judge who then asks them, or the judge allows them to ask questions themselves. In order to reach a judgment, lay assessors must vote in the same way as the judge. Abstentions are not possible. A two-thirds majority is required for a conviction. At the district court, the two lay assessors have this majority over the professional judge, and at the regional courts, the three professional judges do not have a sufficient majority if both lay assessors vote against. In addition to traveling expenses, lay assessors receive compensation per hour for the time they miss, for the disadvantage of running a household, or as compensation for loss of earnings up to a maximum of €73 per hour. When I myself was an assistant lay assessor and soldier, I continued to receive my salary from the Bundeswehr, so I had no loss of earnings and therefore only received reimbursement of traveling expenses. Just as professional judges must remain the same once the trial begins, the lay assessors must also follow the entire trial in order to be able to pass judgment at the end. Just like professional judges, lay assessors can also be rejected due to a bias. The lay assessors in court can often be recognized by the fact that unlike the professional judges, they do not wear robes, but civilian clothing. Judges without robes, Richter ohne Robe, is also the name of the newspaper of the Bundesverband ehrenamtlicher Richterinnen und Richter e.V., Deutsche Vereinigung der Schöffinnen und Schöffen, DVS, which was founded in 1993 after the first state association, Deutsche Vereinigung der Schöffinnen und Schöffen, Bund ehrenamtlicher Richterinnen und Richter, Landesverband Nordrhein-Westfalen e.V., was founded on 25th of February 1989. Thus, there is a voluntary association to support the honorary judges. Remarks, additions, and comments in the comments. Thank you for your attention. See you in the next video.